We want to welcome you to the Medicaid Monday, which we're going to cover nursing home care. This is the firm of Pierro, Connor, and Strauss. I'm Pierro. Frank Hemming to my left. Your right is our Medicaid expert here at the law firm. And we're very happy to be bringing you today an agenda that will cover income and resources for Medicaid, exempt assets and transfers, preserving non-exempt assets. And if you are looking and facing nursing home care, then you have to do this in a very particular way. We have something we call the rule of halves. If you have a spouse living in the community, there is something called spousal refusal. And what steps can you take now if you need Medicaid or want to plan ahead? So that is the agenda for today. And I'm going to turn it over to Frank Hemming to talk about what we see in our firm as clients come in and they either have spouses or parents or other relatives or loved ones who are in nursing homes. And Frank, that is no longer child's play.
No, it's a huge amount of expense every month. We have the numbers on your screen now. Whenever we ask clients, I asked one literally today when I was meeting with some people, what do you think a nursing home costs? Just to see what they thought. And wife said 5,000. Husband said no, it's way more than that. I'll say 10. Well, it's actually more in the $15,000 to $17,000 range, like you're seeing here. If you're in the Albany area, if you're downstate in New York City or closer to that neck of the woods, it's actually probably a little bit more. So if you do the math, without trying too hard, this cost can go over $200,000 a year. And that's exactly the amount of, that's the total amount of money that would really put a hurting on people's finances if you had to pay that month after month, possibly year after year. So what a lot of people do when they want to come in to talk to people like us is they want to plan to have that paid for without it coming out of your pocket. And that's when we go to Medicaid to help pay for that.
So roughly 70% of all nursing home beds in New York State are financed by Medicaid. And people get there in one of two ways. They either spend all of their assets down and then apply and qualify for Medicaid, or they do some planning, either advanced planning or what we refer to as crisis planning. We're going to cover both today. But for those people who are relying on nursing homes to file their Medicaid application, Frank, I think it's safe to say that you won't get advanced planning or crisis planning along with that. So if there are assets that want to be preserved for spouses at home or for children or ultimately grandchildren, a little bit of planning is necessary because these are the Medicaid levels, Frank.
Yeah, so again, like we go through this every Medicaid Monday. So again, if you're new to the series, welcome. If you're a single individual at home, your income limit is $1,752 a month for income. If you're a couple, it's $2,371 now per month. And then if you're the spouse living at home for either a Medicaid person in a nursing home or a Medicaid person in your home with you, your income allowance as the community spouse, that's that $3,853.50 amount.
But don't be confused by that because those are home care income levels.
Yes.
We have a series on home care eligibility, which we're going to be talking about later in the program coming up for July and August. But Frank, that income level is not as good if you're in a nursing home.
No, that's actually that depressing bottom number that's there. That's that $50 per month. It's been that way since 1965. That's the one that's going to be most on point for our topic today. And then for your resources, these are the amount of assets you can have. Again, if you're a single person and you want to get Medicaid at home or in the nursing home, your asset limit's now $31,175. If you're a couple where you're both applying at home, it's $42,312. And then we have that bottom number, the community spouse resource allowance. Again, we did a whole Medicaid Monday on the well spouse and everything that goes with that. But again, generally speaking, community spouse can shelter about $75,000 free of any issues. It's all right there.
So these numbers are fairly new. Last year, the increase from 22 to 23 was dramatic.
Yeah, it went from roughly 16,800 to 30,182 for assets for a single person. So it almost doubled. And while, again, the difference is good, it's positive, we didn't see nearly the increase this year that we saw last year.
And if you're watching today's webinar from a state near us or contiguous to us, like Massachusetts or Connecticut or New Jersey or Pennsylvania, the asset limitation in virtually every other state is $2,000, which is the SSI limitation. New York is much more generous in what they allow people to keep, whether they're at home or in nursing home, because the asset limitations, unlike income, apply to both.
Correct. Right. It is just, I think it's just surprising that On one hand, 31,000 is not very much money at all, but in comparison to other states, it's a substantial increase, more than $2,000.
So there are certain assets that are exempt. We just talked about one that is $31,175, and that could be in bank accounts, stocks, bonds, anything that you want that is a non-exempt asset can be up to that dollar limitation. But there are other things, Frank, that can be kept.
Yep, like you have your prepaid burial, again, no limitation on that. So if you want to prepay your burial funeral arrangements, you can. If you have an active business that's producing income, although it's rare, the business itself is an exempt asset.
And that could include rental properties.
It could.
And we typically, if clients have a couple of rentals, we create a business, we create a limited liability company, we put the rentals in the LLC, and it operates as a business. Those are exempt assets. So if you're facing a nursing home situation and you want to exempt assets, you can argue and successfully argue that an active business, including a property management company, could be an active business, and those assets could be exempt at the get-go.
Yeah. I mean, it's not something, again, we see often, but has been a tried and true planning technique that we have used in the past. Life insurance, a very limited amount of life insurance. So if you have a face value at $1,500 or less, right, then that value of that life insurance is exempt. We just don't see that very much because it is a very low number that, again, has been not indexed for inflation. So that's been that number since 1965. The biggest one that I think we surprise clients with is that IRA one. And as long as you have an IRA or any other tax-deferred retirement account, like a 401k, a 403b, a 457 plan, a deferred compensation plan, as long as it's in periodic payment status, it is an exempt asset for Medicaid. But again, it's very rarely seen outside of New York. So if you're in a different place, different state, that's unlikely that that's going to be the case with your IRA, but it certainly is the case here in New York.
Florida is the major exception. Florida, like New York, exempts retirement accounts. The definition in the Social Security POMS, this is where the Medicaid asset law comes from, says that the IRA must be in periodic payment status. It does not define that term, but it has been implemented by New York State through a 2023 GIS to be interpreted to say that you have to maximize distributions. And New York State has kind of bootstrapped itself into a position, Frank, where they're no longer using the IRS table, which is a generous table, longer life expectancies, a 2-life table. They're using the Social Security table, and more counties are jumping on that bandwagon.
Yeah, which at the end of the day, what it means is they're requiring more money to be taken out of your IRA to have it fit this criteria of being in periodic payment status. If you're at home, there's ways to protect your income. So if they increase your income, there's ways to protect that increase in income. But if you're in a nursing home, like the cases we're talking about today, right? If you have increased income, really what it means is it's going to be more money having to be paid out to the nursing home on a monthly basis.
A lot more the older you get, because life expectancy under that Social Security table shrinks very rapidly as you get into your 80s and 90s. So it's pushing more money out that has to go to the nursing home from the retirement account. And Frank, at this stage, I think it's worth mentioning that as you're looking at nursing home care, which is today's topic, you have an opportunity to spend down on certain items. You can spend down on exempt assets. You can prepay more than just your funeral and burial.
You can prepay burials for many family members. So it could be children, it could be siblings, it could be spouses of a lot of these people. So we have had clients in the past where they have some excess, not a ton, but they buy prepaid burial arrangements for other family members to get rid of the money above $31,175, and then they get Medicaid eligible very quickly. So if you're looking for a Christmas gift 6 months from now, maybe a prepaid burial.
You can trade in the 72 Volkswagen Beetle and buy a real car.
We have had clients do that as well. Like if you're 20,000 above the limit, but your loved one could use a new vehicle, right? If you go and you use that car to visit them, we've had clients do that. So again, one car is exempt. Again, we don't put a value there because Medicaid doesn't put a value on it. Could be a Lamborghini, probably won't be, but it could be.
You can buy clothing, you can buy a television. You can't buy 6 televisions. We actually had that case where somebody thought they could go out and just keep buying TVs for everybody in the family. Nope. One TV would probably get through. But this we call the spend down. And to get down to the minimum amount of money that you have at risk, those non-exempt assets, you want to be as aggressive as you can with the spend down. If you have a spouse living at home, or a blind or disabled child, or a caretaker child, the home becomes an asset that we can do some good work with. You can transfer the home to any of these individuals, caretaker child, sibling with an equity interest, disabled child, or your spouse. But if there is someone, your spouse, living at home and you don't want to transfer title, you could actually make home improvements. You can spend money on the home if there's an exempt individual living there. And you can also, Frank, file something called an intent to return home. And a lot of people say, well, there's no way they could go back home, but that doesn't really stop it, does it?
No, it doesn't. It's a creation of federal law that allows you to do this. And it's, as we put on the slide, it's subjective intent. So it doesn't mean that it actually has to be a reality for you to do that. It's just that you subjectively intend. You yourself believe that you want to return home. It doesn't mean that you actually have to return home. It's that you want to return home. And if you do that, we typically use that in cases where we don't have a protected individual, like a caretaker child, like a spouse, like a disabled child, exempting the home when we're applying for Medicaid, because without that as subjective intent, they could count the residence as a resource and then you don't get Medicaid. So we use it in that instance too.
So what happens is you can own the home and you don't have to give it away, and you can file the intent to return home. But as Medicaid is paying bills on your behalf, and you still win a little bit because you're on Medicaid and they're paying at a much lower rate than the private pay rate.
Yes.
So, and this is why having a nursing home file your Medicaid application may not be in your best interest, because financially they're much better to have you spend all of your money down and save nothing and then go on Medicaid than to get Medicaid sooner. And if you do get Medicaid, they can put a lien on the home, and then anything that you would save in equity in the home, depending upon how long you're in the nursing home, could be lost. So pre-planning for the home, getting it out into a trust is really the way to do this, getting it out there in advance. But if it's a last minute thing, we can even use a revocable trust if possible, because that's the only way they recover.
Yeah, because a revocable trust would at least keep it out of your estate for probate purposes. And that's how they recover, is against your probate estate. So if it doesn't go through your probate estate, they can't recover.
So on the right, you see the community Medicaid rules. Again, we're going to cover those in July. And then we're going to talk about the assessment process, immediate needs, MLTC, all the changes that have come in those programs. That's going to be August. But for today, we're going to focus on the left bubble, and that is chronic care Medicaid. And you can't get Medicaid if you have given assets away. And Frank, this is a process that you go through with all of our clients. Just talk a little bit about what that process entails.
Yeah, so that's what we're really getting to, is the 5-year look back period, where essentially it's when you apply, the local county Medicaid office will require financial documents for the past 5 years or 60 months. And then they audit all of them. They look at what you've been doing over that 60-month period, and they try to figure out if you've given away or transferred things away from you to the benefit of someone else, right, over the last 60 months. If they find that you've given gifts, they total all them up, and they divide the number of the gifts that they found by the penalty divisor, which we have a slide coming up about. And then ultimately, it's a math problem, and they come up with a period of ineligibility before Medicaid will pay for your nursing.
We're lawyers. We don't like math, but we do it. We'll give you that slide in just a moment. But there are other things to think about. There may be innocent transfers over that 5-year time period, and there are some special rules. If you've given assets away exclusively for a purpose other than to qualify for Medicaid, that may be exempted as a transfer, but you're not going to get that right out of the gate.
No, because if it was easy to get, everyone would just file their application, and then any gift or transfer that was found, they would just say, well, I didn't mean to, I wasn't trying to apply for Medicaid when I did that. Of course, I didn't mean to do that. But the standard is quite high. I know in the past when I've researched this issue, like if somebody had, I think the way of explaining it the best is, this exception is mainly used for people when they were perfectly healthy, had no reason to think they were going to need Medicaid, and then some freak accident or act of God led to them needing a nursing home, where they had no reason to think that was likely to happen, like a car accident, like a sudden health event where there was no medical history or family history of it. That's where that exception is mainly used and is successful. Not that you couldn't argue it, but you're not always successful if the circumstances are different than that.
And it also is judged by, did you render yourself insolvent?
Right.
Is it a gift that was just a $10,000 gift to a grandchild, or did you give everything away to the point where you couldn't support yourself?
Right.
So these are facts and circumstances that go into those determinations. as to whether transfers can be exempted. And there are actually exempt transfers. As we mentioned, you can transfer to a disabled child, you can transfer to a spouse. That's any asset. So if you have a child with a disability, you can transfer $1 million to that child, and that will not disqualify the child, or excuse me, that the transferor, but you have to be careful what benefits that disabled child is receiving.
Yeah, big thing, right? If you have a disabled child for planning for mom or dad, or, you know, in that instance, that's good because it gives us planning opportunities to exempt things, but you don't want to mess up benefits for that child.
So wherever you are in New York, this covers you, and you can find your county in the different regions. We are sitting today in northeastern New York, where the divisor is $13,235. Our other office is in Manhattan, in New York City, so that's $14,273. And how does that number play into this, Frank?
So they take the number of, or the total amount of your transfers, and they divide by this penalty divisor. So if we're dealing with, so if it say it was $100,000 and we divide it by 13,235 in Albany, you get one number. If you're in New York City, you take 100,000, you divide it by 14,000 and change. So you get a slightly lesser penalty in New York City for the same amount of stuff that you've given away, just because the math works differently. You're taking a same number dividing it by a larger divisor.
And so when you're doing planning in this realm, you have to look at all of the things we just talked about, the spend down, how can you get money down and reduce the amount of non-exempt assets. And then you take those non-exempt assets and you give gifts, and you divide that gift by the 13,325, or it's 230.
Yeah, slight typo.
Or if you have gifts that you've made in the past within that 5 years, they get aggregated, they get added together, and you have to account for prior gifts in addition to any current gifts. You then do this to use the divisor. In this case, 158,820 gives you a 12-month penalty period. So you aren't ineligible for 5 years. You're ineligible for 12 months, provided you've triggered the penalty, Frank.
Right, which it doesn't always start running, right? You
Right.
have to be in your nursing home, you have to be spent down to 31,175 or less, and you have to submit your Medicaid application. Up until you do those three things, your penalty doesn't start to run. And I think the biggest thing is, well, what happens is if I haven't done anything, right? We have families that come in all the time where they say a loved one needs a nursing home. They didn't do any planning. We've been trying to have them do planning, or they just did some planning. We haven't made it through the 5 years. So what do we do in that instance? And that's when we get here to the rule of halves or the promissory note and gift plan, where essentially we do a whole lot of math. We do have some examples coming up in the slides where we can save approximately 50% of the assets.
It's not a perfect 50%. You don't get half a cookie, but it's pretty close. So this is an example. I'll let Frank take it after I give you some facts. Bob A, has $3,550 a month of income, $385,175 of non-exempt assets. Again, that's not the IRA. That's not a house if there's an intent to return home. This is the aggregate of non-exempt assets. Nursing home costs of that $16,000 a month that we talked about. Total spend down of $34,000 on things like a funeral. You can prepay children's spouses, buy the televisions, the clothes, furniture, and you can prepay your legal fees for the work that's going to be done to get you Medicaid eligible. So this kind of comes off the top in the spend down. Bob then gifts $110,000 to a Medicaid Asset Protection Trust and loans $210,000 to Junior, all on June 28th of this year. So walk us through the math.
All right, so I'll do my best I can, right? So we take our income right at the top, we take his income of $3,550, we take the $50 allowance off, so he's at $3,500 net of income. We take his nursing home cost, $16,000 a month, we subtract his income. That means that he has a shortfall of $12,500 per month to pay for that nursing home. Second part of the slide, we talk about his assets. Well, we told you what they were. It's $385,175 to start. We spend him down $34,000 on his funeral, his burial, his legal fees, his other items that he needs, and then we leave $31,175 with him. So our total at-risk money is $325,000. Then we do our math. So we take our gift of 110 plus our prior gifts of 100. That means we're giving away approximately $210,000 total to the trust.
So when we say rule of halves, you have to factor in the prior gifts. It isn't just I can give away half today. If you've already given away the 100, that's
Right.
part of that.
So if he hadn't given away the 100,000 previously, we'd be doing it now, and he'd be giving away 210 total. But he already gave away 100, so we got to throw that back in the math. So you take 110 now plus 100,000 you already did, that leaves 210,000 that we're giving away to that Medicaid trust total. All right, and then we're loaning the other half, the other 210,000 we're gonna loan with monthly payments of $12,500. That's exactly the number that we needed to have it pay for the nursing home. So we do all the math, we then apply as of July 1 because we had to make the transfers at the end of June because Medicaid looks at what you have on the first of a month. So we got the money away from him at the end of June. We get all this set for July 1, we apply as of July 1. And because we gave away the $210,000 total, that triggers a 15.87 month penalty. So essentially a 16-month penalty. So now that penalty is going to run from July 1, 2024, when we submit our application, up and through the end of October next year, 16 months from then. So the penalty runs until essentially November 1, 2025. Our note runs from July 1, 2024 up until the end of October 2025, the exact same time as that penalty. So that way, when we get to November 1, 2025, now Bob is down, he's spent down, now he goes on Medicaid for the remainder of his life.
Why the heck would you want to run through all these hoops? History lesson. In 2006, the law changed. Prior to 2006, you could simply give assets away. The penalty period started to run immediately, and then you'd keep enough assets to private pay until that penalty period was exhausted. In 2006, they put some punitive provisions in to say the penalty period doesn't begin to run until you're already in the nursing home. You're otherwise Medicaid eligible, so this penalty period doesn't run until you're below $31,175. Well, how the heck do you get below $31,175 and still have money to pay the nursing home, right?
That's the problem, right? You can't do all this and then give all your money away and then have everything trigger and now all your money's gone unless you can get it all back and now you're in a different set of circumstances.
And then we have to file the Medicaid application. That's a 3-pronged test. But if we've done this and we've done the loan, which is not an asset, it's an income stream, and we've done the gift, we have money flowing in to private pay the nursing home while the penalty period on the gift runs, and we're back to the rule of halves transfer. And what's the result?
So here's exactly why. When Lou said, why would you do this? This is why you do it. Because we saved $110,000 to Bob's trust. We saved another $31,175 just sitting with Bob. So we kept that away from the nursing home as well. We prepaid his burial contract for roughly $12,000. We bought him $10,000 in personal property, and we exempted the $100,000 that he previously gave away that we didn't have to have come back, or the nursing home or the county didn't come back, or the kids or the beneficiaries for getting that money. So when you add all that together, we actually saved Bob $263,000 and change by doing all of this, rather than have him spend all of it down to just that $31,175 and then getting nursing home at that time.
So you've given assets away, you've loaned assets to somebody. What could go wrong?
Essentially, Bob could pass away during all this. That's a big one that we constantly get questioned about. Obviously, the other one is we want to make sure that that loan money and that gift money that we put aside is only used for the correct purpose. So this brings back into other parts of the plan that we want to put in place while doing all this, like making sure Bob has a good and trusted power of attorney to make sure that somebody's actually managing the money appropriately, making sure that loan payment happens once a month, every month for 16 months, that gift money is still off to the side, because if Bob needs something, if he spends through that $31,175 in his account, well, the only other money that the family has of Bob's is the gift money in that trust. We want to make sure that's being managed properly as well. So there's some things that could go wrong. Obviously, Bob could pass, we could have untrustworthy people, but if you're doing those types of things and keeping those things in mind with the whole plan, this should go pretty good.
That's why the trust is a better option than outright gifts, because once you make outright gifts, the cat's out of the bag, money's gone, it's hard to get back. What about if the income level changes or the expense changes?
So if the income level changes, it's really that first month that we're worried the most about. So if the income changes and it goes down, if something happens in that first month, we might have to undo this and redo this. We hope we don't have to do that, but that does happen sometimes. Like if there's a hospitalization, something like that. If we're past the first month and then something changes, then most of the time we just write it out, and if we have to go into the trust a little early to get some money, or we have to go to another source of money if there is any, we sometimes look at that. We kind of take as much into account as we can to try to deal with the problems.
What if income goes up?
If income goes up, then we're shortfalling less, which as long as he's not accumulating money in his bank account long term, we should be okay there too. So maybe we would have to spend some more money to get him down below that asset limit if we have to.
You don't want to get over the expense level, because from an income perspective, if you have more income than you have medical expenses for that month, you may be ineligible.
Right.
So that would extend the penalty period. So a lot of calculations, a lot of math, a lot of complex documents. The promissory note is a complex document in and of itself. You have to apply an interest rate. All this has to be done properly. But this is the way that people who are already in a nursing home or about to go into a nursing home can plan to save roughly half of their assets. Now, for married couples, there are other options.
Yeah, as fun as that sounded, I'm sure, if you're married and you have a spouse that's well, we actually don't have to go through all of that. We can use something else in our toolbox, and that's mainly something called spousal refusal.
So there is no penalty period. Remember, if you followed along earlier, there is no penalty for transferring assets to a spouse. So when one spouse has assets, they can transfer it to the other spouse. The other spouse can then sign a piece of paper saying, I refuse to turn those assets over because I need them to pay for my own care. You have to be a little careful here, because if it's being done under a power of attorney, you have to have gifting authority in the power of attorney to be able to do that. We've actually done this through a guardianship. There is a lot of case law and precedent that you can do Medicaid planning through a guardianship, but you want to have a good, well-drafted power of attorney for things like asset transfers at the last minute. And for spousal refusal, it's good, but it's not perfect, because there are remedies that the state has.
Yeah, unfortunately, they can sue you. We talked, I think, quite a bit about that when we did our Medicaid Monday on spouses' rights and things. I believe it was in February. So it's not usually the worst thing if you get sued and you're the spouse, as crazy as that sounds, because as Lou kind of alluded to earlier with the liens, if Medicaid comes back and sues a spouse, typically they can only sue and recover what they've paid out on your spouse's behalf, and Medicaid doesn't pay what the spouse would be paying privately if they'd never gone the Medicaid route in the first place.
So it's still a win. You get a discount of about a third off the private pay rate. But there are other numbers that we have to be aware of in spousal planning. The minimum monthly maintenance needs allowance, otherwise known as the MMMNA, is the income allowance for the well spouse. There are ways to get increases to that income allowance. If the well spouse, for example, is in assisted living and the other spouse is in a nursing home, you can get an increased income allowance to pay for the healthcare needs of the other spouse, including home health care if you want to use those expenses. And then there's the community spouse resource allowance, which is that higher level of assets for the community spouse. So the MIMNA is what nursing homes really want to get, and sometimes don't.
Yeah, so the community spouse current level for this is $3,853.50. But as Lou said, there are certain circumstances where that could be increased. The only time I've ever seen it in the fair hearings, though, is, as Lou said, is for health care of the well spouse.
It used to be a much more liberal standard, but they clamped down on that in some case law.
Yeah, so unfortunately, like one of the questions we get a lot is, well, if I need to support my house and I need more than that to support my house, is that going to get us a higher level? And unfortunately, most of the time, based on what I've seen, I don't think it will. It's more of like, I have an assisted living, I have home care needs, or I have home health care needs, things like that. That would be a much better argument, just to say my property taxes are high.
So the NAMI is actually the net available monthly income. So once you calculate the MMMNA, you have a number that you have to pay in income to the nursing home, and that's the NAMI. And you have to pay that. I mean, that's something that's an obligation to be paid. And then the CSRA could also be increased to increase the income of the community spouse if they're under income.
Yeah, again, it's not something that we see frequently, but the fair hearings are actually very strong in favor of the spouse here, where if you have less than your community spouse resource allowance, or if you have less than your income allowance, your MMMNA, then sometimes they allow an increase in the CSRA to do some income planning to bring the spouse up to the increased amount of income. That is something that I do see.
So how safe is spousal refusal and how secure is the spouse refusing? Depends on what county you're in. Remember, there are 62 counties in New York, and 5 of them are in New York City covered by HRA. The rest have county departments of social services, and your county attorney determines how aggressive they're going to be in approaching spousal refusal. And so you have to know what county you're in. We file applications, probably 25 counties or so that we file in, and you have to know where you are. The applicant has to sign a right of support over to the county, and the state and county have a right then to come back and seek contribution toward the cost of care. Obviously, and we've done a whole series, and part of that is one full session on the Medicaid Asset Protection Trust. Getting out in front of this and waiting out the 5-year look back is by far the best way to do this, and the best way to get out in front of it is the Medicaid Asset Protection Trust. And that brings us through 30 minutes of Nursing Home Medicaid. I hope that was understandable. All of these are on our website, pierrolaw.com videos. You can get the entire series and follow it from every aspect. The two that are coming up are two of our favorites because this is where a lot of people want to be. And there are only 111,000 nursing home beds in New York State and 4.6 million people that are over the age of 60. So as we go forward, people are going to be taken care of at home and going to need services at home. So July 8th at noon, we're going to cover financial eligibility for home care, pool trusts, income spend down, asset transfers.
No promissory notes.
No promissory notes. We don't have to worry about that today for home care, but what's coming?
If the look back happens, which we think could happen in 2025, you could see promissory notes needed for home care. We actually did, I think, a webinar about that back in 2020 when they announced the changes, and that's a little more complicated than even the one we talked about today. There's some unknown variables there.
And the state has kicked the can down the road because of COVID, but also after COVID. And part of that is that the complexity of enforcing these rules just has to be sorted out. And they haven't gotten there yet. They're telling us perhaps sometime in mid-2025 that look back period of 2.5 years, rather 30 months, will be applied to home care applications. So we're going to cover all of that in part 1 on July 8th. Part 2 is once you're financially eligible, because that's actually the easy part, then you have to get the care. And you have to go through a series of assessments, the NIA assessment, the physician assessment, independent physician. You then have to go to a managed long-term care assessment, and MLTCs then take over and decide on the number of hours that you get. There are fair hearing rights that go along with that if you don't get the hours that you need. And so we'll talk all about that, and then what has evolved because of the time frame. And how long does it take, Frank, to get a standard Medicaid application processed to the point where you get care in the home?
4 to 6 months these days, I would say, because the other thing that unfortunately has happened is many Medicaid offices now are severely understaffed. They were understaffed anyway. COVID has not made this better. I don't think I can think of a single office where we haven't had some delay. Some are longer, some are not as long, but unless you're going to immediate needs, that application is going to be hanging around probably longer than it used to, just because of staffing issues on the county side.
So immediate needs is a 12-day turnaround time. That's the statute. And so we're going to talk about that on part 2, August 12th at noon. Hope you can join us for those. Thank you for joining us today for Nursing Home Medicaid. And as always, thank you for joining Medicaid Mondays. Frank?
See you next month.
See you next month. Thanks, everyone.